Hello, everybody, and welcome. So I thought what I'd do, since most of the recent developments are in the condo conversion world as opposed to in the TIC world, I thought I'd reverse my normal order of doing things and start with condo conversion stuff. That's what I'm going to do. We'll talk about the basics of the 3 condo conversion programs, and also focus a little bit on the issue of ADUs and condo conversion, since we get so many calls now every day about ADUs and how they relate to condo conversion ability and also to TICs, that I thought you guys must be getting those same kinds of questions, so it'd be a good thing to cover in some detail. And then after we get through the condo conversion stuff, we'll talk a little bit about airspace subdivisions, which is another really hot topic down at the San Francisco Department of Public Works, which I've actually haven't talked to Zephyr about before. So that'll be something new. And then we'll do the TIC stuff to the extent that we have time. But again, there's not a lot of new stuff in the TIC world to report. There's a lot of TICs and a lot of activity, especially in other parts of California. In Los Angeles, we're seeing an explosion. We think that there will be 2,000 TIC units entering the market in Los Angeles between now and the end of the year. So really a big developments down there. But up here, the market seems very steady. No changes in the law or anything like that. We'll come back to that. Okay, so starting with 2-unit bypass conversions, just to remind everybody of the basics. So the most important thing that people miss on the 2-unit conversions is there has to be more than one owner. If there's only one owner, or if it's a married couple that owns the whole building, they can't do the 2-unit bypass conversion. You need a different owner, meaning not married to each other, in each unit. Each owner has to have at least a 25% interest in the building on title. So if somebody wants to do it with their sister-in-law or with their daughter or with their parents, they have to put the parent on title. It's not enough that they're a relative. They actually have to be on title. So 2 different owners on title for at least 25%. We do quite a few what we call sort of straw man transactions, where there's no financial transaction between the parties, but we are putting someone on title for 25% just to create the eligibility. San Francisco DPW, which by the way stands for Department of Public Works, I think everyone knows that, they don't care about the financial aspect. The only thing that matters is the person is on title or they're not on title. How that happens is not an aspect of eligibility. Once the owners are on title and in their units, they have to be there for a year. Once they reach that year, then they become eligible to submit an application. The application processing right now is down to about 9 months on average. We were about 7-8 months ago, we were at a year and a half. So it's a significant improvement. There's been a lot of turnover at DPW. People often ask, is this building that I'm thinking of buying, is this building that I own eligible to convert through the 2-unit bypass program? And the answer is every building is eligible to convert unless it's got a tainted eviction history. So that's the question, is what was the eviction history of the building? The answer is at the rent board, which maintains a file for each building describing its eviction history. And what will disqualify the building from a conversion altogether under the 2-unit bypass is if there has been a no-fault eviction in the building of a protected tenant since November of 2004. What's a no-fault eviction? That's an eviction for something that wasn't the tenant's fault, like the owner wants to move in, the owner is going out of the rental business under the Ellis Act, the owner wants to do renovations, anything that's not the tenant's fault is a no-fault eviction. What's a protected tenant? It's a tenant that's old, sick, or disabled. That's the short version. There's some nuances here, which I'm not going to go into, but that's basically what you're looking for. So if there's been any no-fault eviction of a protected tenant going back to 2004, then the building is disqualified. The other thing that is problematic is if there were 2 or more evictions in the building. Even if, let's say, neither of those were of a protected tenant, that still has an impact. It doesn't make the building ineligible for the 2-unit bypass, but it makes it take much longer. So instead of being 1 year of owner occupancy, you need 10 years of owner occupancy, which is a really almost like making it ineligible because that's such a long time. But it's technically still eligible. Now, the other thing besides eviction is the tenant buyout law, which is more recent development. And I'm not going to talk about it much except to tell you that it exists. And the reason I'm not is because right now, the DPW is not considering buyouts as having an effect on eligibility for either 2-unit bypass conversions or the next type of conversion we're going to talk about, which is ECP or expedited conversions. Neither of those cases are they looking at the buyout history at all. So for now, I think we can say that tenant buyouts are not relevant to the eligibility of buildings to convert under the bypass program. That could change, but that's the policy as it sits right now. So I want to talk about now 2 slightly strange complexities in the 2-unit bypass program that are relatively new developments, and they're somewhat related. The first has to do with illegal units. Now, in the old days, if we had an illegal unit in the building, if we removed the illegal unit, that restored the eligibility of the building to convert under the 2-unit bypass program. That is no longer true. The position of the planning department, so this is not coming from Department of Public Works, this is coming from planning. The position of the planning department has been that if they know about the illegal unit, if there's some record of it somewhere in the city, the building is not eligible for the 2-unit bypass program at all, regardless of whether you legalize the illegal unit or remove it. It's simply ineligible because the Department of City Planning is taking the position that this is not a 2-unit building, even though the 3rd unit was illegal, which is not really a legally logical position. It's more of a political position. What planning's policy calculation is here is they want more rental units, so they don't want to create an incentive to remove the illegal unit, and they don't want the unit to become a condo. So effectively, the position they're taking is, look, you have to legalize this unit, and you're not going to be eligible for conversion. So it's sort of a worst case, a perfect storm of problems. If you've got a 2-unit building with an illegal that at some point or another has been acknowledged through an enforcement action or a prior attempt at legalization or something, it's basically you have to tell the client it's not going to be convertible under the 2-unit bypass program. The other big issue, as I mentioned, is the ADUs. So as you may know, there's 2 ways that people are permitting ADUs. One is through the standard ADU program, and the other is in connection with a seismic retrofitting of the building. There are some slight differences in terms of how these methodologies for permitting the ADU end up affecting its convertibility. But in the case of 2-unit buildings, as opposed to, say, lottery buildings that we'll get to in a minute, in this context, it doesn't matter. Regardless of how you get your permit to do the ADU, the result is the same, which is this. If the ADU has been added before the building has, the conversion of the building has been attempted, then you can't convert through the bypass program at all because it's considered a 3-unit building, even though it's an ADU. So if somebody comes to you with a building, or they're thinking of buying a building and they want to add an ADU, but they also want to do a condo conversion, the thing you have to tell them is don't do the ADU yet, wait, okay? You either want to do the ADU while you're doing the conversion simultaneously, meaning that you make the building eligible by owner occupying it first, then you would apply for conversion, and then you build the ADU while you're converting. Or you want to wait, do the conversion, finish it, and then do the ADU after. But what you don't want to do is do the ADU first and then attempt to convert the building, because then it's a 3-unit building. Now, the second thing about this is that the ADUs are not going to be a condo. It's still only going to be 2 condos, okay? ADUs are, in this context, accessories to other units. So it means that you're going to have a condo with an ADU as part of it. Still a separate dwelling unit, but it's part of a condo. Or you can even have a condo with 2 ADUs as part of it. Doesn't matter how many ADUs there are, it's still one condo. So for example, if you had a 2-unit building and you could build 2 ADUs, you could either have each condo have an ADU, or you could have one condo have 2 ADUs and the other condo have no ADUs. But what you can't end up with is 3 condos or 4 condos or something like that. Still has to be only 2 condos at the end of the process. So that's the 2-unit conversion. Hey, I didn't see you back there.
So if it's, because they're new construction, those aren't under price control?
Because, sorry, run that again.
Because they're not.
So it's a rent control question, right?
Yeah.
As far as I know, an ADU is still under rent control, but I'm not the person really qualified to answer that. We don't really do that.
Because it's new construction, it's not under price control, but it is under rent control.
Okay, I don't know. I'll go ahead.
So that means that an ADU needs to always be sold with the condo, correct? It can't be sold as a separate title.
It can't be sold as a separate title. I thought you were going to ask me about TICs, though.
Yeah.
So the really interesting answer to, I think, to that question is that theoretically, yes, it could be a separate TIC interest.
Okay.
So what you're going to have is sort of a condo TIC hybrid where you essentially have 2 tenants in common buying 1 condo, and 1 tenant in common is assigned the sort of main unit, and the other tenant in common is assigned the ADU.
But you wouldn't be able to, sell it separately as is, correct?
I don't. Can you elaborate on
Well,
that?
like you wouldn't be able to sell just the ADU.
As what?
The TICs.
No, I think you could.
So that would be what, 100% of a TIC, percentage-wise?
So you would be selling.
No, the tenants in common. So we'll get to this in more detail later. But the tenants saying something's a tenants in common means there's 2 owners or more, right? So let's say this is 1 condo consisting of a main unit and an ADU, right? So you could have 2 tenants in common. Their percentages would be whatever they are. It's not really relevant. And 1 tenant in common would be assigned the main unit, and the other tenant in common would be assigned the ADU. Now, when the tenant in common assigned the ADU wants to sell, they can sell.
Okay.
What they're selling is their percentage along with the right to occupy the ADU. I think that the trickiest question with ADUs as TICs is, what about the financing? So far, as far as I can tell, Sterling at least doesn't seem to care if it's an ADU or not. They'll lend on it regardless. But I don't know actually what the other lenders are doing, because it hasn't come up yet. At least if people are doing it, they haven't been telling me, oh, we're hearing yes, we're hearing that. So I just don't know. But as far as I can see, the biggest lender doesn't seem to care whether it's an ADU. I still would check. I still would ask if you have that deal. Go ahead.
If you have a single family home and it has an illegal unit, you go down the road and legalize it. Can you condo convert that?
It depends what you're legalizing it as.
As a legal unit?
So not an ADU. Because
Illegal unit to a legal unit. So you're
just a plain legal unit, a full-on unit, then yes, absolutely.
So it wouldn't be exempt from like condo.
It's not considered a conversion at all because it was just a house before. So all these conversion laws, like the 2-unit bypass, those are rules about converting an existing apartment building to condominiums. But in this case, you're not converting an existing apartment building, you're converting a single family home. The reason the ADU is problematic is because in the ADU law itself, it imposes restrictions on the eligibility of the ADU to become a condo. That's why I was asking you, how are you legalizing it? In other words, when you go to pull the permit to legalize it, what kind of permit are you pulling? And this raises a really interesting slight digression. I don't want to digress too much here, but a lot of times when you go to planning now, when you ask about legalizing stuff, they tend to push you toward the ADU side because it's so much easier to meet the requirements to get a permit for an ADU. You don't have to worry about lot coverage ratio and density requirements. You get exempt from all of that. And so the tendency is to push you toward the ADU. And it really is worthwhile to have the potential applicant ask, well, if I wanted to make it a full-on unit, as opposed to an ADU, could I get the variances? You know, maybe I would need these 3 variances to get it to be a full-on unit. It's much easier from the planning perspective, from the standpoint of the bureaucracy, to push you toward the ADU where they don't have to process variance applications and all that. But what you end up with is much less, right? Because it's an ADU and it comes with all this ADU baggage. Whereas if you got the variances and you legalized it as just a regular unit, it doesn't come with all those special ADU restrictions. Okay? So ECP, so Expedited Conversion Program, was enacted in 2013 with the purpose of getting rid of the huge backlog of lottery people who are losing year after year after year after year. The program is now in its last year. So the 2019 generation is the last year of ECP, and the deadline for submitting this generation's application is January of 2020. So we just have a few months of ECP left. I won't spend much time talking about this, but you might know some people who are eligible, so I'll just quickly go through the eligibility requirements. It has to be an existing TIC. So if it's, again, 1 owner, not going to work. 2 or more owners can work. It's expensive, okay? Much more expensive than a 2-unit bypass, and that's because of the $20,000 per unit impact fee, which goes into an affordable housing fund. Any renters in the building get a lifetime lease, regardless of age, disability, et cetera. Owner occupancy requirements are for 3 to 4 unit buildings, 1 owner occupant, and for 5 and 6 unit buildings, 3 owner occupants. And it's that number of owner occupants for 3 years. Just making sure I'm getting this right. Yes, running up to the date of application, so 3 prior years. You can tack owners times on top of each other, so it doesn't have to be the same owners continuously for the owner occupancy period. Eviction history issues come up here too. No fault evictions since 04 of a protected tenant, that is. No fault evictions of anyone at all since the beginning of the program, so April of 13. And again, that if you have the 2 no fault evictions before 13 and they weren't protected, you push that owner occupancy period out to 10 years. Tenant buyouts, again, in this context, are not being considered. So you don't have to worry about tenant buyouts for the ECP. The big thing that's going on right now in ECP is that somebody filed a lawsuit. I don't know how, those of you who may remember the big fight in 2013, remember that there at the last minute, there was something called the poison pill that was put into this law. And what the poison pill basically said was if somebody challenged the legality of the requirement to give rental tenants lifetime leases, then the program would be suspended. And we all thought that was going to happen at the beginning, and it didn't. And years passed, and then we thought, oh, well, guess no one's going to file a lawsuit. But all of a sudden, a couple years ago, someone did. So well into the program, it had been running for years and years and years, and then they filed it. And so as a result of the lawsuit, which is still pending in the courts, the city has suspended the processing of all applications for buildings with tenants, and they are not accepting any new applications for buildings with tenants. So this means even though if you meet all of those requirements that I just described for the ECP, you still can't apply. And if you did apply before the lawsuit was filed, your application was put on hold, and you're just sitting there. And the really interesting question that we're wrestling with about this right now is, what happens when ECP expires and these people who have either been suspended or prevented from applying are no longer eligible because the program has expired. Is there going to be some kind of window that opens up after the expiration of ECP to let these people in? Because for a lot of these people, they will never be able to qualify. For example, 5 and 6 unit buildings under the lottery system, when it comes back, I'll talk about that in a minute, they aren't going to be allowed to enter the lottery. So if you're a 5 and 6 unit building, this is it. And so we've been pressing DPW for an answer. What's going to happen to these people who are being prevented? And unfortunately, they don't know either. It seems fairly clear that the buildings that were suspended, so the buildings that had applied before the lawsuit was filed, and so those guys are just sort of in limbo, those people will be processed after the lawsuit is resolved. Assuming that the lawsuit doesn't just strike the whole law down, but that seems extremely unlikely. But they have no idea what they're going to do about people who were eligible to apply and were prevented from applying because they weren't accepting applications. So that's left us in a bit of a conundrum because we don't know whether it will matter whether people have tried to apply or not, right? So imagine building A says, well, they're not going to accept my application anyway. Why spend all this money getting a map and all this stuff and submitting the application if they're not going to accept it anyway? And building B who says, well, we're going to go ahead and submit it and at least get a marker in there. We tried and you said no. So what we've been telling people is we don't know what's going to happen here, but if you want to submit an application, we will. And we've had some people take us up on that. We've been submitting these applications with a letter saying, we know you're going to reject this, but here's why we're submitting it anyway, on the theory that later on, we'll be able to say, look, we tried. You said no. Now we think that these people should be allowed to go forward. So no idea what will happen on that. Go ahead.
I think maybe you work with like clients that are buying a 6 unit in a TIC and the listing agent said they found out later on that 2 of the people it's not their primary residence. So my question is, what is the documentation the city uses to prove that? Because I think everyone thought they were, but they, I don't know, have a place in Klein Village for tax reasons. They have their business there or whatever. So the people didn't know. So what does the city actually look at to know if it's their primary residence or not? And can that be overcome if in that building, for example, the people next year file their taxes in San Francisco?
Okay, so the answer is that it used to be that the city verified it by looking at utility bills, but they stopped doing that a long time ago, and now they rely on the sworn affidavit of the applicant. So the only thing they get is a piece of paper signed in front of a notary that says, I swear I've lived there. And unless there is some reason to doubt the veracity of that, like for example, a tenant comes forward and says, hey, they're lying or something like that, they don't do any further inquiry. So now that doesn't mean people should go in there and lie about it. And to the question of, is there a way to overcome it? In other words, could you be honest and say, no, actually, this wasn't my primary residence, but can I apply anyway? The answer is no.
On the lawsuit, was it an individual or was it a trade group like?
It was an individual. Are there any other questions about this part? Where are we here? Just a couple quick, I talked about the apply and get a rejection. Another thing that people are doing about this problem of not being able to apply if they get desperate enough is they're putting the tenants on title. So we've had several people do this. Most recently, somebody put their tenant on title for like 0.2, a tiny, tiny percentage, which actually shouldn't even be allowed because the official requirement is 10%, but it went through anyway. It's risky, obviously, to put people on title when they have no skin in the game, so to speak, but some of these 6-unit, 5-unit people are so desperate to do this, and they've been waiting so long that they're willing to take the risk. So
is that when the tenant's a relative or not necessarily? I don't know, like their
I mean, you mean in the cases when it's happened, was someone related to the tenant?
yeah. Is it
Not as far as I know. Okay, so the last way to convert a building is through the lottery system. The lottery has not happened since 2013 when ECP was enacted, and it is scheduled to return in the mid-2020s. It will either be 2024, 25, or 26. We don't know yet which year, and the reason is that the calculation of which year it will be is based on how many buildings, and more specifically, how many units actually converted under the ECP. We don't know that yet. So once the ECP ends, and they see exactly how many units have been converted, then there's a formula, and they will determine which year the lottery will come back in. So I expect we'll know by 2021 which year the lottery is going to return. As I mentioned a couple minutes ago, no more 5s and 6s. So the maximum number of units that can be converted through the lottery system will now be 4. So we're talking about 2 units, 3 units, and 4 units. These are residential units, by the way. Commercial units don't change. So you can have 6 commercial units and 3 residential units, and that's still a 3-unit building from the standpoint of lottery eligibility. The biggest change in lottery eligibility, besides the elimination of the 5s and 6s, is how many units will need to have been owner-occupied for the 3 years. It used to be just 1 for 2, 3, and 4-unit buildings. It won't be anymore. Now it's all but 1. So in 3-unit buildings, that means 2 owner-occupied units. In 4-unit buildings, that means 3 owner-occupied units. Same kinds of restrictions regarding eviction history, but a new one, which is no-fault evictions during the 7 years preceding the year you win. So that's yet another eviction history related requirement. And also the buyout, the tenant buyout law, this clearly applies to the lottery. So at that, when the lottery comes back, we will need to be looking in every case, not just at the history of evictions, but also at the history of the buyouts. And the buyout tracks the eviction. So in other words, in terms of when something becomes ineligible. So in other words, if you've done a buyout of a protected tenant, that's going to make the building ineligible. If you've done 2 buyouts, neither of them protected, it's not going to disqualify the building, but it's going to give you that long 10-year owner occupancy instead of the normal 3-year owner occupancy. So back here to the ADUs for a second. So going back to the example we were using before, the 2 units plus the ADU, if you legalize that ADU and you did it in connection with a seismic retrofit, as opposed to doing a normal ADU, right? So we've got normal units, we've got ADUs that are under the normal ADU statute, and then we have a third category, which is ADUs done with a seismic retrofit, just yet another permit. And that law is slightly different, and what it says is that in a lottery conversion, you can make that ADU its own condo, not an accessory to another condo. So that's the one exception where you can actually make the ADU a condo on its own. It's just if it's a seismic retrofit ADU. Okay, so just a few quick things, red flags in condo conversion. The owner occupants, as I mentioned before, need to be on title. So that means no LLCs. Trusts we've been able to get through, but only if the owner occupant is both the beneficiary and the trustee. So a true living trust, but no like family limited partnerships or complicated estate planning trusts with a third party as a trustee. Vacant units are not considered owner occupants, owner occupied. Vacant units are vacant. Owner occupied units are occupied by owners. They're not the same thing. It's amazing how many people call me and say, oh, I live in one unit, the other unit's been vacant for years. Doesn't that qualify? Well, no, because that unit is vacant. For eviction buyout history, don't rely on what the seller tells you. Definitely pull the rent board file every time. Building condition, I think you guys probably all know this, but it's not, the building does not have to be up to current code. It's just that everything in the building has to have been legal when it was built. So in other words, everything has to be either original construction or built with a permit. Where you have the problem is when you have stuff that's been added to the building without a permit, like an illegal deck or an attic that was developed or an illegal room in the basement, something like that.
What about firewalls and sound?
So no sound issues, but the firewall issue sometimes comes up in connection with the garage. And it seems to, my sense is that it's a inspector by inspector thing, that some inspectors cite it and some inspectors don't. It very rarely is something we see, but I have seen it on these reports. And it can be expensive to put up.
Oakland requires sound and fire.
You don't have to do that.
Can I ask a question? I have a listing coming up of a condo that is a 3-bedroom, 2-bath in a condo converted in 2017. The tax records say it's a 3-bedroom, 1-bath, and we don't see any permit where a second bath was added. But it still obviously went, successfully went through condo conversion.
In other words, you know the bath was there when it was converted.
Yeah, so then, so what's the disclosure for us now? I mean, just by virtue of the fact that if it passed condo conversion, is it in the eyes of the city a legal bathroom?
Yes,
Oh,
because that's a full inspection.
Okay.
Anything that's not permitted is supposed to be cited. And then at the end of that process, you get a certificate of final completion and occupancy. So I think it's legal.
Okay.
And Andy, we do have one question from Eric in the webinar audience. He says, what happens with the condo conversion if after the conversion process starts, there's a change in ownership in, looks like he's saying, in ownership of the building of one of the units?
There's no law on that question. So all we have to go on is the practices that are being followed by the Department of Public Works at any particular time. And currently, they don't seem to be flagging, let's say, or derailing conversion applications based on changes in ownership. So at the moment, at least we can say it's not affecting it. Obviously, since there is no law, we're depending on continuity of policy within the department, which we might not get. And so if people are debating, well, should I sell, should I wait? It's better to wait because then you're taking no risk. Whereas if you sell, you're relying on this policy, which theoretically could change. So it'd be better not to, but if you're in a situation where you absolutely have to go, then at least so far, it hasn't been fatal.
Got it.
Last thing about this, if people are worried about something in the building from an inspection standpoint, there are pre-inspectors you can hire to go in, not city employees, but private people who are experts on conversion requirements who will go into the building and give you a report about what they think is going to be cited. Now, this is just a prediction. I don't know for sure, but they tend to be pretty good on what they think you might want to do prophylactically before the inspection. Quickly on the conversion costs and timing. So city application fees plus or minus $13,000, including the inspection. The impact fee I mentioned before, this is only for ECP. So it's $20,000 per unit. The land surveyors have gotten a lot more expensive. So plus or minus $7,000 for the map. Attorney's fees, about the same, $4,400 for 2-unit. These are our fees, there's some, but it's pretty competitive. $4,400 for 2-unit buildings, $5,500 for 3s and 4s, and $6,500 for 5s and 6s. And as I mentioned before, they're running about 6 to 9 months, a little bit longer for 5s and 6s because they have to go to the board of supervisors and the planning commission at the end. Okay, so moving to something different, which is this issue of airspace subdivisions. The reason this is interesting is because it used to be that we used to have, the DPW used to have this elaborate policy about when a newly constructed or newly added unit could be made a condo. And they made these distinctions based on, well, was the building built in the base? I'm sorry, is the unit in the basement? Is it inside the envelope, outside the envelope? Is it half in the envelope and half out? Is it in the yard? And there were all different rules. Well, not anymore. Because now DPW has glommed onto this idea of the airspace subdivision. So what's an airspace subdivision? So it's best to understand it in comparison to what a condominium is. So a traditional condominium is a box of air surrounded by actual stuff, floors, walls, and ceilings. So if this were a condominium, the boundaries would be the walls, the ceilings, and the floor. It's still air. It's just that it has physical boundaries that we can go touch, right? What's an airspace subdivision? It's the same thing without the physical boundaries. Okay, so it's a box of air without the box. And how it gets defined is by the surveyor creating a definition that's based on imaginary planes and surfaces. Okay, so, you know, a vertical plane that begins along this boundary line and goes up 8 feet, and then there's a horizontal plane where that 8 feet ends that goes across 6 feet and meets another vertical plane, but there's nothing actually in these things. It's just imaginary. So the way this is working with new construction now is if you put in a new unit in a building, whether it's inside, whether it's in the basement, on the roof, in the back, or multiple new units, you can make them all separate lots. They're technically not condos, they're considered lots because this is not a condo thing, it's an airspace thing, and the terminology is lot. So what happens is, let's say you have a 3-unit building, existing 3-unit building, and you add another unit in the basement. Well, that unit can be its own parcel right away. And you can sell it separately with its own financing, not as a TIC, as an actual lot. The other lot is the existing 3 units. Okay, so effectively, after you do the airspace subdivision, you have 2 lots. You've got the new thing that you built. You've got the old thing that was the 3 units. And then there can be common area that they share. And that lot consisting of the 3 units, that still remains eligible to do whatever you could do before with it. So it could be condo converted later on if it wins the lottery, for example. It could be sold as a TIC share or whatever. So this is very popular for people who want to add some density, and they want to be able to sell the new things that they built right away, not as TICs, but as things that can be financed more readily in the same way you could finance a condo or whatever. Go ahead.
So notice the example you just used, that basement there's just a basement. But if you do this airspace subdivision, then you can go, it's a separate parcel now, you can go in and put a bedroom and a bathroom and do whatever you want with it?
Well, you have to be able to put the unit in there. So you still have to be able to get a building permit for it. So in other words, if adding a unit in the basement is not possible because it doesn't have enough ceiling height, for example, or the lot is already maxed out, you can't add another unit on it or something, then this doesn't help you. But if the law allows you to add a unit, not an ADU, by the way, because ADUs have their own restrictions, as we've talked about before. But if you're adding it as a legitimate unit, then it goes straight to being its own parcel, even though it's in your basement, which means it's worth more and you can get better financing on it. And if you're building like 3 units in the back, you have a big yard or something, you can do an airspace and condo subdivision at the same time. So each of those 3 units is a condo. And your original building in the front, however many units it was, it's its own lot, but it's not a lot with the other new units. And eventually, if that becomes eligible for condo conversion or whatever, it can be converted. And then the whole map gets redone and then they're all condos. I know it's complicated, but that's.
As long as it meets all the building requirements.
Yes, yeah.
So,
What about rezone?
to do that?
Yeah.
It depends on the lot and what you're trying to add. So in other words, if you've got a lot that is zoned for only 2 residential units and you have 2 residential units, you can't do it. But if you've got a lot that's zoned for 3 residential units and you only have 2 residential units, then you can do it. There were some other hands.
Is this a San Francisco thing, or is it in other cities?
It's in other cities too,
California,
but
but it's city by city, basically.
yeah, I mean, every place has its own rules about subdivisions. And there is a state law, but the state law, controls certain things, but gives a lot of discretion to local governments to decide how they want to regulate subdivisions. Go ahead.
The building's zoned RH3 and you only have 2 units, but no room on in the garage. Can you sell that lot if it's going to require ripping off the roof and adding the unit on top?
Well, I don't know the answer specifically about RH3, but the easy way to answer this is if you can build it, if you can put in a separate unit, then you can make it a separate thing for sale purposes.
Even outside the envelope?
Even outside the envelope, yes. Okay, go ahead.
It sounds to me that it would be a lot subdivision. If you have an extra long lot, you could add a structure and in the back. That's the airspace. So it's almost like a lot subdivision there.
That's a really good, I'm glad you brought that up because I should have brought it up myself. So I think what you mean when you say a lot subdivision is what was traditionally referred to as a lot split, okay? And that's where you're actually splitting the ground in a sense. In other words, and the thing about lot splits is that either the resulting lots both have to meet all of the requirements for a lot, meaning the right length, the right width, the right setbacks, a building, there has to be a rear yard setback and a side yard setback, and you need to have access, street access, right? So all of those things were required for a lot split. So if you had, say, a 25 by 180 foot lot, right, where you had a house in the front or a multi-unit building in the front, you couldn't do a lot split because your back one wasn't accessible unless maybe it was on an alley. And even then, you had the width, but you didn't have enough length to create 2 25 by 100. So that prevented you from doing a lot split unless you could get all the variances you needed, lot size, setbacks, width, whatever you needed. The difference here is there's no requirements for this airspace lot. There's no setbacks, there's no size requirements, there's nothing. If you can get the permit to build the unit or units, then you can do the airspace subdivision. It doesn't matter. So that's the difference. If you have that 25 by 150 thing, you couldn't do a lot split, but you could do the airspace subdivision. Now you still have to be able to get a permit to build more units back there. But assuming you can get that, then you can do this. That's the difference.
Because you would have the tradesman entrance, which may be still there.
That's right.
So that would take you to the back.
Yeah, and they don't care about parking anymore. The whole parking thing went away. That used to be the other restriction that created a problem here. But so now, and plus, planning is all over giving people permits to build more units. That's like, 10 years ago was the opposite. But now people have realized, if we actually build more housing, that will mean we have more housing. It's only recently that people figured that out. And so now, it's becoming easier, still way too hard, but it's becoming easier than it used to be.
Do you anticipate a moratorium at any point down the road with all these?
A moratorium on?
New buildings.
I hope not. I mean, I hope we build it.
Have that.
I hope we build
20 years ago.
Tons of new, what we need, obviously, here and in all these cities with housing crises is we need 100,000 new apartments. That's what'll solve the affordability problem. We need to change the way the city looks and feels. And so long as we're resistant to doing that, we're going to have an affordability crisis. Because all we're doing right now is we're allocating a limited resource, right? And in order to allocate a limited resource, you have to decide on winners and losers. And if you're going to have winners and losers, some of those people are going to be losers. That's the reality, but nobody wants to admit that except me. Okay, one last thing about ADUs. So adding ADUs to existing condos. So far we've been talking about ADUs in the context of existing before a condo conversion or being constructed during a condo conversion or being constructed, let's say, immediately after a condo conversion. But what if you already have a condo building and you want to add an ADU to the condo building? So that is always allowed if you don't want to make the ADU a separate condo. So if you just want to make it part of an existing condo. There is also a very obscure exception that in the ADU law that says if you have something that was already a condo by July 11th, 2016, I won't even try to explain why that date matters, and it was not rented in the 3 years before that at all. It was vacant or used by the owner, and there was never a no-fault eviction during the 10 years before that. Then you can add the ADU and make it a condo. Ridiculously complicated, but there is this rule. So this means that the condo has been around for a while, since 2016. This can't be like a recent conversion or a newly created condo, but if it was a condo when this law came into effect and it meets these eviction history requirements, you are allowed to add the ADU and make it a condo, another condo. Okay, so I'm now going to talk about TIC, but before I do, does anyone want to ask any condo questions? No? Okay. So I can tell that this group is pretty much veterans and probably knows a lot about TICs already. I don't know about these other people in these other places, so I'm going to just quickly review the basics, even though you guys are going to be bored. So what's a TIC? A relationship. It describes a relationship. So somebody comes to you and says, hey, I own this building by myself and I want to create a TIC. And I say, oh, great. So you're going to be selling some of the building or all of it? Well, no, I thought I'd just create a TIC and keep it. Okay. So this person doesn't understand what a TIC is, right? Because they can't create a TIC between themselves. I can't have a TIC agreement with myself. I can't be a tenant in common with myself. It's a relationship. Each person owns a percentage. It's not like joint tenancy, where if one of the owners dies, the other owners end up with that person's share. That's the difference between a tenancy in common and a joint tenancy. Rights of survivorship. Why should TICs have a written agreement? People often assume that without an agreement, certain normal rules will apply, and they're wrong. For example, it's not true that majority rules if you don't have an agreement. Majority may rule if you do have an agreement, depending on what the agreement says, but it's not like if I own 55% of a building and you own 45% of the building, and we don't have an agreement, that I have more power than you. Okay? It's not like without an agreement, if I'm living in the upper unit, you can't live in the unit. You can come knock on my door and say, hey, I'm moving in with you, or I want this unit, get out. So there's no rules without an agreement about who gets to live where. Also, if there's no TIC agreement, there's something called the right of partition, which means any owner can force a sale of the building anytime they want without any reason. So because of those three things, it's very important if you're going to have a co-ownership to have an agreement. There's lots of other good reasons for agreements also, but these are the main ones. Why do people do TICs? Why don't they just convert the building to condominiums? Well, we've talked about that in the San Francisco context because there's these strict rules about when buildings can be subdivided into condominiums, and those rules actually don't just exist in San Francisco, they exist in most places in California and in most major cities where there's any kind of a housing shortage. And so TICs are a workaround for that. People do TICs because it's either impossible to subdivide or too expensive or too uncertain. And they're looking for ways around it. So if this is a way around local subdivision laws, Why hasn't the government made it illegal? Why are they allowing a way around the law? And the reason is, the answer is they've tried to make it illegal a number of times, all the way going back to 1986. And each time that's happened, the matter has been challenged in court, and the courts have decided, no, this is the right of people to enter into private contracts about how they're going to share ownership of something is beyond the reach of government. We're not going to let government tell people what they can agree to do with a building that they share. So these cases have been decided in a series of decisions every few years going back to 1986. Now, the one thing that these cases have not allowed people to do is record the TIC agreement. So, or record anything that assigns a unit right to somebody. If the deed says, or the trust deed on the mortgage says that you own the upper unit and I own the lower unit, then we've subdivided and we violated the law. So to be a TIC that's protected under this kind of umbrella of court decisions, the one thing that has to be true is that the unit assignment that we've agreed to in our private agreement needs to be just that, a private agreement. The minute it goes on record in a deed, or we record our agreement or whatever, we cross the line. And that's because of the way the courts have come to this place of deciding it's because they're saying what's protected is our ability to agree among ourselves how to use our shared building. But the minute we go further than that, and we say, okay, and now it's a matter of record that this is my unit and that's your unit, then we've subdivided and we've broken it.
Could you go back to the prior slide for a second?
The one before? I can send you all the slides, I mean. Okay. ADUs, again, visiting the ADU section again. So ADUs as TICs. So I mentioned one of the two things that we've been worried about here, which is the financing. And as I already said, so far, at least Sterling, the biggest bank, has not been saying, oh, if it's an ADU, we won't provide a fractional loan. The other thing that we've been worried about is the DRE. So as we're going to come back to this in more detail in a second, but as most of you probably know, big TICs, meaning 5 or more units, go to the state for approval. And what we've wondered about is if some of the units are ADUs, will the state still approve it? And the answer is so far, yes, but that could change. So at least at the moment, they don't seem to care whether the units are ADUs or not ADUs. We still are able to get through the approval process. So people are building ADUs and they don't want to just make it part of a condo, for example, so they even qualify for condo conversion. There is this possibility of selling the ADU or ADUs as individual TIC interests.
Andy, we have a couple of questions coming in from the webinar. I do want to let everyone know that we'll be posting the recording of today's session to Zephyr Training. That should be live on Wednesday. And we are also going to make Andy's slide deck available for download. Probably going to host that on Google Drive. Our first question here is, if in a 4-unit building, all are equal size square footage or 25% each, is the MRI also the same percentage? And do insurance companies look at TICs any differently than other buildings?
Sorry, what does MRI stand for here?
I'm going to lead on the audience or someone in the live chat to tell us what MRI is.
Mortgage research insurance. Let me break it apart, and then they'll let the questioner can come in and see if I've answered or not. But so sure. First of all, it's not necessarily the case that because the units are the same size, that each owner would be 25%. Those are two different things. It could be that whoever organizes a TIC decides to do it that way or not. It doesn't matter. There's no law that says, oh, if all the units are the same size, then all the percentages must be the same. The second thing to say is that the ownership percentages have nothing to do with how expenses are split, unless we decide that it does. So in other words, in this agreement, we're going to say, how are the property taxes split? How is the insurance split? How is this split and that split? I'm not going to put in mortgage here. So let's take mortgage on the side for a second. The other expenses, how each of those are split is something that the agreement is going to say, and the agreement could say it will be according to unit size, or it could say it will not be, it will be equal regardless of unequal unit size, or it could be based on the relative value of the units or any other criteria. And also, there was an assumption in the question that, for example, the insurance would always be broken up the same as, let's say, maintenance reserves. That could be true, but it isn't necessarily true. So we have the ability to play with all of these things when we create the TIC agreement. Now, if the M in the MRI was the mortgage, there was also an assumption in the question that this was a shared mortgage, meaning that the mortgage is allocated according to the TIC agreement, and everybody is contributing to the payments on a single mortgage, which of course is not the most common model anymore for TICs. We still do see an occasional group loan TIC, but 90+% of the market, everyone has their own loan. So with all that, maybe if the questioner has a follow-up, because I'm not sure I actually answered the question.
Right, and the attendee did clarify that the M was for maintenance. So this is a maintenance repairs insurance. That's the MRI.
So again, maintenance could be equal. It could be based on square footage. It could be based on relative value or anything else.
Fair enough. And we have this other question. Who usually draws up the map for TICs, floor plans for units and storage area, et cetera?
So in large buildings that go to the Department of Real Estate for approval, we need a surveyor to do it. They want the map to be really professional. In small buildings, 2 to 4, where we don't go to the state for approval, we don't have to have a surveyor, and in fact, it's quite expensive to get the surveyor. So generally speaking, it's the seller or the group or a group member who is creating that. A lot of people use appraisers' drawings or pest control drawings as sort of a template to, and they trace over it, or they use that to draw it on a computer. So it varies, but generally it's not done professionally. Some real estate agents have gotten really good at doing it on their computers. So I get some really cool color-coded ones now from agents, which are nice. The most important thing about the drawing is you don't need to show what's inside the units. I get some of these that are like floor plans, and here's the toilet, and here's the kitchen, and it's actually better if you don't put that on there. It's too much information. So what you want is just the perimeter boundary of the units. And another question that comes up on these drawings is square footage. Should we put the square footage on the drawing? No. Don't put the square footage on the drawing unless you're a surveyor. It's too much liability. The last thing about the drawings that I'll mention is parking. If you're drawing a parking diagram, or if you're looking at one that your client has drawn, remember to think about the fact that not only is it important that people are able to get their car into the space and out of the space, but they need to be able to get out of their car. Just being able to get into the space is not enough. If you can't open the car door, so we'll get drawings where somebody, here's the garage, and here's the line down the middle, and this side is space A and this side is space B. Well, what's the problem with that? Well, if people park right against the line and you've got a big car, maybe you can get in there, but then you're stuck. So I always suggest now that people draw a little corridor in the middle, maybe 3 feet wide or something. Well, then inevitably what people say is, well, then people with bigger cars won't be able to park. And yes, that's the point.
That's exactly right. Because if your car is too big to fit in the garage and still open the door, it is too big.
And if we, pretend, and then people will say, well, that's not a problem as long as one person has a big car and one person has a small car. But the thing that happens here is that later on when someone goes to sell or they get a bigger car, the person who first had a bigger car says, oh, too bad I had a bigger car first. Who said you could get a bigger car? And that's not a good result, right? I mean, so we want something that's durable enough to withstand changes in circumstances. Go ahead.
Two things. You said if it's over 4 units, you have to get approval from the state. You're talking about condos or TICs?
TICs.
It's the same rules.
Same rules as condos, yeah.
But why do they have any authority over TICs?
Because of a law called the Subdivided Lands Act. And the Subdivided Lands Act, which is in the Business and Professions Code, is a consumer protection law. And in that law, which is quite lengthy, you probably know this, there is a section that discusses the concept of undivided interest subdivisions. So it's like divided and undivided at the same time. And that's where TICs fit.
Second question, I assume when you sell a TIC, it'd be considered a change of ownership. I'm sorry, convert a building to a TIC. Would probably change your property tax.
It's not the converting that's changing it, it's the selling.
The selling.
Yes, so it's the recording of the deed, right? So when, let's say it's a 4-unit building and you're doing 425% shares. So when you record the deed for the first 25% share, that triggers a reassessment of the building. When you record a deed for the second 25% share, that triggers another reassessment of the building. And so the building gets reassessed every time you record one of these deeds. And the interesting question is, well, how much does it get reassessed for? And the way they do it is they look at the sale price of the percentage that's being sold. So let's say that you had a 4-unit building and the assessed value of the building, you've had it a long time, the assessed value is $400,000. Okay, and then you sell your first TIC interest for $1 million. Okay, what happens to the assessed value of the building? Well, you've kept 3/4 of it, and that had an assessed value of $300,000, 3/4 of $400,000. You sold 1/4 for $1 million, so that has an assessed value of $1 million. So what's the new assessed value of the building? $1,300,000. Okay, and how is that tax allocated among the 4 owners? Well, in this case, 2 owners, right? Because you still own 3/4. And the answer is you pay property tax on $300,000 and the buyer pays property tax on $1 million. Why? Because that's what the TIC agreement says. No other reason. Go ahead.
I haven't done TIC for a while.
Why not? Get with it.
I know, but I have just 4 units, and before when I do a lot of TICs, and you have to close simultaneously for doesn't matter group loan or fractional loan. And now it sounds like you don't have to close simultaneously.
Correct.
You have to close one at a time.
So the one wrinkle is your old loan. So now if you had the 4-unit building that was free and clear, then there's nothing to worry about. You could close serially, right? But let's say that you have a loan on the building for $1 million, okay? The problem is that in order for that first TIC sale to close with its own loan, you've got to get rid of your old loan. So let's say you're selling that first TIC interest for $1.5 million. Well, that's no problem because now you have enough money to pay off your old loan. But let's say you're selling that first TIC interest for $750,000. Well, that's not enough. So either you need to close 2 at the same time, or you need to come up with another $250,000 from somewhere, like maybe get another loan, like a TIC loan on another unit or something like that. But you need to have enough money to pay off your old loan because you can't have the old blanket loan and the new fractional loan there at the same time. You can only have one or the other.
When did that happen, when the law changed? That
It was never a law. In fact, we had people closing serially even back when there were only group loans. It just was more complicated, so people tried to avoid it. But it was never a law that said you had to close simultaneously. A lot of sellers prefer it because they don't want to be in the group. You know, sellers own the whole building for a long time and they're used to deciding everything themselves, and they don't want to suddenly be in a group dynamic where there's another owner. And so a lot of sellers say, you know, I just want out all at the same time. I don't want it to happen gradually. But one sec. But the benefit of the serial closing is, first of all, if you have a really, you know, great buyer, a great offer, but they need a place to go and they don't want to, you don't want to risk losing them and they don't want to wait around, you can just close it. The other big benefit is if you've got a building, you don't want to do an Ellis Act eviction, you've got some rental tenants. So you decide that sort of, well, I've got one vacant unit and 3 tenant occupied units, maybe at least I can monetize my, because otherwise, right, what are you going to do with the vacant unit? Either you got to re-rent it, then you're back in the same mess, or you've got to sit on it vacant and wait for the other ones to become vacant. Well, that doesn't sound very good either. So selling the one as a TIC is a nice solution because you can at least, you know, liquidate that one, even if you're going to sit on the others. Fine.
So in your example, you had one buyer and then the original developer owns the other 3. And what would your recommendation be as you sell additional units that each member gets 1 vote, even though that owner owns 3 units, so they each have 1 vote? Or would you suggest 3/4 gets 3 votes? And
so it's a really interesting question. So in our thinking on it has evolved. For many, many years, all the agreements had what we called vote merging, which meant that the person who had the multiple shares would still only vote once. Then we started to get a lot of pushback on that. People said, oh, it's not fair, you know, if I own 3 shares or 2 shares, I should get more votes. So we started taking the vote merging out and just giving it 1 vote per unit. Now what we generally do is we ask people. You know, we say, okay, well, do you want it this way or that way? And so I'm not sure I really have a recommendation. I think if I was going to be in the group, I'd want vote merging.
What's that mean?
It means that no matter how many shares you get, you only have 1 vote. There is one wrinkle to this that's important to understand, which is, I mentioned earlier, but I'll say it again. It's not necessarily the case that majority rules. So the fact that you have 3 votes and I have 1 vote doesn't actually mean that you make every decision, but it means that you make most of the decisions. Big decisions still require my vote, and that's because in the agreement, it's tiered decisions. Certain decisions maybe require a majority or a supermajority or unanimous. It's not always, but still, most day-to-day routine operating decisions are going to be majority decisions, and if you have 3 votes, you are going to make those decisions. Go ahead. Somebody.
Usually those decisions are monetary. You know, you're deciding, you know, adding, replacing a roof. So really, the 3 votes is going to be that's their portion. So
That's the argument.
So that makes sense.
Until you ask. Yeah, I mean, some people will say, well, if I'm going to pay 3/4 of the cost, I should be making the decision. And that's the argument against vote merging.
but that's overridden by the fact if it's leaking, you have to repair something that's damaged in the building. So it overrides that decision anyway.
Well, it depends which decision. The decision you're talking about is, do we repair it or not? You know, do we fix the leak? But beyond that sort of threshold decision, there's all these other decisions that are in there, like how do we do it? Do we just patch it? Do we replace it? Do we use roofer A or roofer B? So all of those things, and those things do impact the person with just the 1 vote. But they arguably impact the person with the 3 votes a lot more, right? So the 3 vote person might be motivated to just patch it. whereas the one vote person might be motivated to replace it with the best possible roof.
Because the cost, right?
I have one more comment. That's why it's always good to have a odd number. So it'll always be a 2 out of 3 votes, or it can't be a standstill where you have to
Yes.
mediate now, right?
This is the problem with 2 units, right? So it doesn't matter whether it's a TIC or a condo or a planned development or whatever. The most difficult ones to operate are the 2-unit ones, and they have more disputes that go to mediation arbitration. And many people who call me, both agents and just regular people, will say, oh, this is simple, it's just 2 units, It's not like those really complicated 3-unit ones. And there's just a natural assumption that if there's fewer people, it's easier to operate. But in fact, the opposite is true. The smaller the group, the more difficult it is to operate. The bigger the group, the easier it is. And that just has to do with this decision-making issue and also the way the dynamic operates among people. So 2 units are tough, and we definitely, most of them work just fine, but they're more likely to have problems. Go ahead.
Transferring a unit, I assume with fractional loans, it's much easier to transfer a unit. Does the TIC agreement talk about it, or is everyone, do we always have their own right to sell their own units? They don't have to ask the other TIC members.
Yes, so even in a group loan situation, everybody has a right to sell. They don't have to ask the others. But the difference is that in a group loan situation, there typically are peremptory purchase rights and rejection rights. So you have a right to buy out the other person, but at market value, not based on an appraisal or something like that. You have to match the market. And you have the right to reject a buyer if you have a reason that you can articulate that is reasonable.
But when
Those 2
when
things
separate loan, what happens?
go away. You don't have them.
You don't have to ask
So
anyone
you
else.
just do it, right? And the reason for that, because we still have clients that want those in their agreements for fractional loans, but the banks won't allow it. So if we put that stuff in, you can't get the fractional loan.
Oh, the difficulty, restrictions on
That's right. The
selling.
banks don't want those things in because they want to be sure, A, that when they take a loan on a unit, that it's not tainted by some prior failure to give a right of first refusal. And if they take it back in a foreclosure, they can sell it without having to worry about the other owners.
I don't see foreclosures of TICs, but here.
There's been
Do you see them?
2 so far since the inception of fractional TICs in 2002, and both in the East Bay. Actually, no, there was one in San Francisco, I believe.
We have one from the webinar here. Question is, does insurance cover the value of replacement for the building or the increased value in selling TICs, i.e. $400,000 to $1.3 million?
The insurance is not going to be based on the sale, the value of the thing at all. It's going to be the first thing, basically. It's going to be based on the cost to build it, to replace it.
Got it.
A lot of the things on these slides that are coming up, we've now covered in answering the questions. No government approval process for TICs. People will say, well, what do I have to do? How long is it going to take? It's going to take me as long as as long as it takes us to write the agreement. Unless it's a big building, it has to go to the DRE. No building inspections, code compliance, state approval, if it's 5 or more units, of which 1 or more is residential. Key differences between TICs and condos. Condos, you own a unit, box of air, we talked about that before. TICs, you own a percentage of the building, and the only thing that gives you possessory rights is the unrecorded agreement, not your deed. Owners need to sign the agreement. Why? Because without the agreement, there's nothing, right? There's just a percentage of the building. Now, this seems, perhaps everyone's going, yeah, of course, owners need to sign the agreement. You would be shocked. I say this in every talk, so some of you have heard me for many years, have heard me say this every time. You would be shocked how many people never signed their TIC agreements, or if they did, there's resales, and those people who bought in never signed the TIC agreement. I would venture to say it may be that a majority of tenants in common actually do not have a fully executed agreement. And Rosemary, who's going to come, I think, at some point, who works with me, the other attorney in our office, this is really a pet peeve of hers. And she's really on people to say, show me that you signed. I want to see that signature. She's right. I mean, because it really is problematic when we have these transactions, resales. A lot of people assume, oh, the title officer, the escrow agent's going to take care of. Well, the escrow agent's not going to take care of me for sure. And you guys aren't going to take care of it.
What's
So
the bank?
they should. But somehow these transactions happen. Property tax, joint obligation paid as part of the dues. I already covered the whole issue of how it's calculated, so I won't go back over that. And I mentioned this last point, which is that if you're the seller, you pay on the value of what you kept. You don't pay an increased tax because you've sold. Go ahead.
But like my clients just bought, so they're gonna get a tax bill from you because you're one of the owners and you're the treasurer who gets the bill, so you're gonna tell me if I bought how much to pay?
I hope not. That could happen.
Well, if you bill during the bill, like
What we
one of the
want to
owners-
happen is we want people to pay the taxes as part of their monthly dues. We don't want to wait till the bill comes and then try to collect it. So what it means is that when there's a resale in the building, the whoever's doing the accounting, sometimes that's someone in the group, sometimes it's SFTIC services, whoever, is going to calculate the dues for that person. And those dues need to be based on that person's sale price, even though it may be a year and a half before the reassessment occurs. That person needs to be paying from the first month based on what their property taxes are going to be. That way, when the reassessment finally happens, the money's in the bank.
No, I'm asking because this building's not this way, and the person buying is a CPA, and she's taking over the treasury, and they've been doing it like every 6 months. Okay, you put this amount in, you put that amount in. It's not built into it.
It's a more risky way to do it. It's not that it won't work.
Yeah.
It's just that it's harder to legally enforce, and there's maybe somebody doesn't have the money, or there's somebody suddenly decides, oh, I don't think this calculation is correct. Meanwhile, now the tax is due.
But the calculation is based on a formula in the agreement.
That doesn't mean people will be able to execute the formula. I mean, yeah, we can have a formula, but we really like, there's some people that really are good at it. You may know Marilyn Alberts, right? Mm-hmm. So the Theo's wife, mm-hmm. who's like become an expert on TIC taxes. So if your group blows up over this, send it to her. Okay. She'll fix it. Continuing key differences between TICs and condos. Enforcement on default. Now there is a convergence going on, but enforcement on non-payment of dues or whatever, it's still much cleaner in a condo situation and less clean in a TIC situation because there's so much law on condos. There's just so much more authority that's been built up. Financing, TIC financing has gotten better, but no 30-year fixed loans still because there's no secondary market. Rates are higher, but they're not that much higher. So that has improved. We always said higher down payments, but that's actually changing too because a lot of the TIC lenders are becoming more aggressive. Tougher underwriting, we always say, but is it actually that much tougher now? Not sure it really is anymore because the market's gotten more competitive. And I think with what's going on in Los Angeles, you're going to now see the big lenders jump in. I think within a year and a half, 2 years, this Los Angeles market is going to make the TIC market in San Francisco look tiny. I mean, and the reason I know that is because when I get a call about a TIC in San Francisco, it's from an agent who says, hey, I have this listing I want to do a TIC, or I have this 4-unit building, I'm thinking of selling it, I might want to do a TIC. I don't get those calls from Los Angeles. Calls I get in Los Angeles are, hi, I've got 65 buildings. I want to do them as TICs. Or, we're a developer, we do 6,000 units a year. We want to get into the TIC business, and we're thinking of, 5 to 10 buildings a month. And I'm getting those calls multiple times in a week. So one of two things is going to happen. Either TICs are going to take over the Southland, or there's going to be such a huge political backlash that we're going to see some kind of further court decisions or something's going to happen. But at the moment, it's just an unbelievable level of interest down there from people who are much bigger players than what we have in Northern California. Do you have a question?
I've also noticed that the difference between TICs and condos, that delta is collapsing.
Some people say, I was on the phone with Charles Moore recently, and he said he doesn't think it exists.
What's that?
And sometimes TICs are.
There's no difference anymore. He doesn't think that condos are worth more than TICs.
And I've seen some that sell for more than cost per square foot, a TIC that sells for more, because fit and finish is better or whatever, than the condo in the same building.
Yeah, I agree with that. The vast majority of people that call me, both agents and regular people, still believe very strongly that there's a difference. Statistically, I don't think there's any support for that, but that's partially because we don't have very good statistics, because nothing is comparable to anything else. So, we're always comparing apples to oranges. We don't really know. But my feeling is there isn't a difference.
As far as
go ahead, why don't you start?
as far as financing, is it the length of time? You're saying TICs are comparable to, say, condos as far as a buyer getting a loan, right?
Well, no, the loans aren't as good. But for example, you can't get a 30-year fixed loan
Right.
for a TIC.
But as far as processing the loan,
Seems the same.
same, okay.
I think so.
So in LA, that's taking off, or supposedly taking off. I assume that's not new construction.
That's a really interesting question. So the answer is for LA, no, it's not new construction. But all of a sudden, we never heard of TICs for new construction until about 3 years ago. All these years I've been doing TICs, and I'm not going to tell you how many now because that's embarrassing and I've gotten so old. But it's been a really long time. Nobody ever did TICs for new construction. The closest thing we ever saw to that was somebody had a lot where you could build a bunch of houses, and they had a house or two on it, and they wanted to build a few more houses. So we did those. But as far as somebody building an entire development as TICs, we never saw that until about 2 years ago. We're doing one, we got called to do one up, it's called Nakoma Golf Ranch. I'm not even sure exactly where it is, somewhere up north of Tahoe. And it's entirely TICs. And now we have another one, it's going to be in the Tahoe area. And the reason people are doing it is because of quirks of permitting, that they're able to get permits to build these units, but they can't subdivide it. So it'll be interesting to see if that turns into a trend or not. But we are seeing some whole developments that are just TICs now.
Just a couple of questions from the webinar. Oh, thanks. So first one is, what is the general ballpark cost for a 2 to 4 unit building TIC agreement?
If they're selling the whole building, it's $2,100. If they're keeping part of it, it's $2,400.
Great.
It's not ballpark, that's the fee.
That's the fee. Got it. And then another one, if in the TIC 2 to 4 units, one owner causes a lien on the property, how does that affect other owners? And will that keep the other owner from selling?
Depends on what kind of lien it is, but let's say a mechanic's lien, for example, that can encumber the whole building, and the TIC agreement deals very harshly with that.
Basically allows the other owners a bunch of remedies, including just paying the loan off, regardless of whether it's legitimate or not, and then doing the forced sale or foreclosure on the owner who caused it and taking the money from that to repay themselves. But the
How about an IRS lien?
We've had several of these, and so far the IRS only liens the interest of the debtor, not the whole building. So in that case, it wouldn't affect the ability of someone else to sell.
Okay, and this one just came in from Dave Cunningham. Can an owner of a 20-unit building change it from rental units into TICs in San Francisco?
Yeah, in fact, we've done 60-unit buildings. Even just in San Francisco, the biggest one is bigger than that. It's like 34 units or something.
There you have it. That's all we have for now. Oh, sorry. One more just came in. David asks, should agents complete the transfer of sale addendum or use an attorney to complete this?
See, this is another area where Rosemary and I don't really agree. The
first thing to say about this is that the addendum was designed to be able to
be done by you guys or an escrow agent or a seller. I mean, that was the plan. But it is the case that a lot of people are just ignoring it altogether, or they're not filling it in correctly, or what have you. And that's happening often enough so that Rosemary at least feels that we should do it an attorney should do it every time. That is just too important. Now, I have some self-interest here, which is that I have absolutely no interest in doing these. So if I sit here and I tell you, send them to us, that means I have to actually do them, which I don't want. Send them to Rosemary, right. No, not the contract, but there is a piece of paper that you do under which the new person signs on to the agreement, says I've read the agreement and I agree to it, and the old person is released. And attached, we call it an assumption and release of obligations. And there's a blank for that attached as an exhibit to the TIC. And then the other thing that needs to be done in conjunction with that is there's the list of owner names, their purchase prices, the units they're assigned, their parking spaces, and so on. So that needs to be updated. The new owner needs to be put in their purchase. So those two things go together, and the questioner was asking who should do that. Fortunately, Rosemary isn't here right now, because if she heard me give you the answer I just gave, she would go ballistic. The official office policy, I think, is really her policy, is we are recommending that you let us do them. That's the best I can do on that.
Can I just say, I just went through this and I recommended Rosemary. Clients didn't want to pay the $350. Kind of like, who's going to do it? Sterling said they would do it, and lo and behold, the clients are paying $350 to some lawyer named Guy Sterling. You know, like, so you should tell Rosemary that.
They can't afford $250.
Yeah, you would think. I mean, think of how much these units are selling for.
They took it as part of bank fee.
Yeah, I mean, what we wanted. So about 7 years ago, 6 or 7 years ago, we invited the lawyers for all the lenders to a lunch, and we pitched this idea where we would have a warehousing system for all of the TIC agreements, where we would keep an original of all the TIC agreements along with all the assumption and release. And to make this possible, what we were saying is the lenders would have to make it an underwriting requirement that an attorney actually have in their file a complete copy of a fully signed TIC agreement and all the subsequent amendments. And our pitch was, gives you much more protection because it ensures that there will always be a complete set somewhere signed by everybody. They didn't go for it. They were like, yeah, that sounds like a pretty good idea. And we kept saying, well, you need to, unless you require this, because we can't require people to do it, right? And it didn't have to be everything at Sirkin. It could be some things at Gelman. Just someone has it. Some attorney has it somewhere. They just didn't bite. And so it doesn't exist. So there is no repository. Unless the group is keeping its own stuff straight, nobody may have it. So. How much time? Does anyone know what time? I can't see the time on this because it's
3:34.
and we have to end at 4. But we've been asking, maybe there's not a lot of accumulated questions, right? Because people have been asking them. So listing a newly formed TIC, these are the steps that you might want to take if you get a listing. So step 1, getting the BRE approval, only needed for 5+ units. You cannot go on the market until you get the approval. No pre-marketing unless you get a special $500 extra, which allows you to pre-market, but then you can only take non-binding reservations and refundable deposits. May not really be worth it. Must use the BRE approved contracts and disclosures. So this is where everybody messes up. Okay, if it's a DRE project, by the way, it's not the BRA anymore. You can see how old this outline is. It's the DRE. If it's a DRE approved project, they approve the purchase contract. And then you have to use the purchase contract. You can't use the SFAR contract or the CAR contract. You have to use the DRE. Now people are always asking, well, why don't you just get the SFAR contract approved? We've tried. We've also tried to get the CAR contract approved, but they won't approve it. So that's why we don't get those approved. Cost of the approval process for these buildings, including the attorney's fees, the surveyor, the budget, it's about $20,000 to $23,000. Step 2, planning the financing. So now pretty much everyone's doing fractional loans. We still ask when we get calls, are we doing the agreement for a group loan or a fractional loan? Very few people are doing group loan TICs, some 2-unit buildings still, but that's it. Why? Well, it's just not that much cheaper anymore to get a group loan. We used to say it was cheaper. And so when you factor in the risk, the extra risk with the group loan, it's just not worth it. Why do we ask when people call us? Why don't we just do the agreement, let them figure the financing out? Because it's a different agreement. So if we do a group loan TIC agreement, can't use it for fractional. If we do a fractional loan TIC agreement, you can't use it for group. So for the same reason, if you're doing a resale and the group has a group loan and they want to switch to fractional loans, we have to redo the TIC agreement.
So Andy, we were actually supposed to wrap at 3:30.
Oh,
so
you can wrap now if you want.
Maybe go to questions now.
Yeah.
Anybody ask questions?
A quick question. Sorry, I lost my voice. So we're jumping back to the beginning, more portion. With everything ending in 2020 and then the lottery not starting up again until 24-ish, what's happening in between?
Good question. 2-unit buildings.
Just 2 units.
Mm-hmm.
And then I also remember back when this first started in 2013, a lot of people were kind of musing that the lottery might not actually ever return. Do you think that's still valid?
No, and I never did think it was valid, but we still get that. You really think the lottery will come back? I mean, it's in the law that the lottery is going to come back. So I guess there could be, some kind of new legislation getting introduced, but I haven't heard anybody discussing it. So it could happen, but I think it's unlikely. It's not very many buildings that convert through the lottery system. It's like 50 to 55 buildings a year. It's a tiny, tiny number of buildings. And for the reasons cited earlier with regard to this TIC versus condo value, another question is, does anybody even really care about condo conversion anymore? I mean, if it went away altogether, would it really matter? Maybe not. Because it's so few buildings and it may not really matter, I'm not sure that there's a lot of legislative impetus to bother getting into a big fight over condo conversion rules and lottery. So. Other questions? So just finishing up, I put up the last slide here just so you could see what we do at our office. Besides the stuff we've talked about today, we also do a lot of equity sharing. Equity sharing is really hot right now. We're doing lots of it.
Can you discuss that for a second?
Sure. What it is?
Well, why is it so hot? Yeah.
I can't really explain why it's so hot. It's been one of these things that's come in and out over the years. But right now, we're doing equity sharing in two different structures primarily. The old-fashioned kind of equity sharing, which is where everyone's on title, the investor and the occupant, and we have an agreement between them. Great tax benefits with this. That's the biggest thing. The investor gets really good tax benefits. The occupant gets money for the down payment. It's a great way for people to help friends, parents to help children, a lot of institutional equity sharing, churches, schools, universities. But one of the most interesting new sources of equity sharing that we're seeing, and I was at a dinner last night, and this just came up spontaneously, is people were saying how, I have these friends and they just have no money. They have a house. They have nothing but Social Security. They have no retirement savings. They can't buy food. They can't pay their mortgage. They can't do it. I hear this a lot now. And the person inevitably will say, and I want to help my friend out. We have huge disparities of wealth. I mean, people have gazillions of dollars, and then these other people who they've been friends with their whole life cannot go to the market. And so you've got a lot of people saying, well, how can I help my friend? So here's the answer, equity sharing. So the other type of equity sharing that we're seeing a lot is, by the way, in that type of equity sharing, obviously the person already has the house, right? So what's the person, the investor person who wants to help is basically doing it by taking equity out of the house, essentially. The other type of equity sharing besides the everyone on title model, is the new way of doing it is with options. And the reason people do that is because it doesn't interfere with the financing. When you have everyone on title, it can be very hard to get finance. We do it this new way with the options, it doesn't. And that is some of these bigger, there's now a bunch of institutional sources of equity sharing. Some of them are my startups that I've worked on and some I haven't. But if you go online, you'll see there's 6 or 7 of them. So there's institutional sources for this also. We do some investment syndications. The biggest part of the business besides TICs is the fractional vacation homes, vacation home sharing, which we do all over the world. Unmarried couples, a lot of family groups, 6 siblings inherit the family home and they want to figure out what to do. We do a lot of that, and we do mediation. So there's the stuff we do. Go ahead.
I saw a 2-bedroom on the market this year where basically you could buy a share, like you get 1 bed, 1 bath, the other person gets 1 bed, 1 bath, they're essentially roommates.
Yes.
Is that an agreement you do?
Yes, we've been doing and we've done some startups that you're gonna see rolling out to make that happen. But also, we kind of roommate-ish situations where a bunch of people live together in the same house. Some of them do it with space assignments, like what you just said. Some of them don't. We also do ones that are hybrids, where they have some tenant-occupied rooms and some owner-occupied rooms. We've done it for university towns where people want to put together a thing so that you've got 6 students all sharing a house, and when student A graduates, the parent of student A, who inevitably paid for that share, can then sell it to student X, who comes in and then takes over that position.
Is there a special name for that kind of agreement?
So is that possible if, like, I have a friend and I have 100,000 and I want to help that friend buy, I don't know, $600,000 condo in Marin to live in? I can take the equity but not be on title for the loan, is that correct? And then I have, I don't know, what, 10% or 15% of equity in that when it gets sold?
Yes, we can do that either by putting you on title or through this option kind of setup, where you're on title not as an owner but in another way.
And that way I'm not obligated by the loan, maybe say that person.
Well, you wouldn't have been obligated by the loan anyway, necessarily. It would have depended on the lender. But your presence on title might have been interfering with their ability to get the loan. especially since the 2008 crash, you know, lenders have gotten more sensitive about this kind of who's on title question. And so this other way of structuring this, where we don't actually make you an owner, we don't want to make you a lender either, because that carries, then you get into a usury mess. So this is kind of a neither a loan nor ownership way of doing it.
So what is the option? What are you optioning?
So what you're optioning is, it's a good way to describe it. So you give the person the money at the beginning. That's effectively like an option fee, right? Then later on, at the time of the finishing event, whether it's a passage of time or the sale of the house or something, a buyout or whatever, at that point, if the recipient of the money, the homeowner, let's call him, if the homeowner wants to just perform as agreed on the contract, they buy out your option for the previously agreed amount, let's say 15% of the value of the house at that time. If they don't do that, then you can exercise your option for very little money to buy that 15% for them for very little more than what you already gave them, not for 15% of the value of the house at that time. So effectively, you end up in the same position.
And why is that better than a deed of trust? It's like
well, there would be a deed of trust in that situation, but I think what you mean is, why is that better than a loan?
Right.
Okay.
With a loan with a balloon payment at the end.
Right. So there's a couple of differences. The first is that most people who do this do not want to make a loan because they don't want the tax treatment of a loan, and the recipient does not want a debt. So then you've got all the regulatory baggage that comes with making a loan and the possible interference with getting another mortgage. So there's a lot of reasons why you probably don't want it to be a loan. You also have the usury problem that I mentioned before. In equity sharing, there is no obligation to pay you back. So if she gives $100,000 to her friend doesn't have to give her $100,000 back. If the deal is she's giving $100,000 for 15% of the house, what she gets at the end is 15% of the value of the house. That could be less than $100,000. The house value goes down. And the fact that it's $65,000 does not mean it's the greater of 100 or 65. It means she's lost money. So it's not really a loan at all. I mean, I shouldn't even say really. It's not a loan.
Would that supersede a trust?
I don't know what you mean by supersede.
Well, would it trump a trust? Like a trust?
Meaning, could the homeowner have the home in a trust and still do equity sharing?
She's asking if they would get paid. I believe she's asking if they would get paid if it's a trust. Would they get the 16% if it's held?
Yeah, in other words, if the trust was a party at the beginning and the trust was making the promise to do X at the end, the trust is just as bound as any other party to do it.
So let's hold it here. We could do this all day. Let's thank Andy for the fantastic.